All right, so thank you everyone for coming to the next of our series of virtual classes here, sponsored by the Smithville Area Chamber of Commerce, as well as the City of Smithville Public Library. And we want to thank our two funding partners, Texas State Library and Archive Commission, and the Institute of Museum and Library Services. Today's class focuses on estate planning for your business. We'd like to welcome our two instructors, Chris Kirby and Frank Weiser. I will allow them to introduce themselves more fully as they start the class. I want to remind everyone that's watching that you can enter your questions in the chat feature at the bottom of the page. Just click on the little button there that says chat, or our instructors tell us they're more than happy to answer questions as they come up. So if you want to enter your questions, they will answer during their presentation, or there will also be a Q&A at the end of the session. So I'm with no more to say. I will go ahead and turn this over to Frank Weiser and Chris Kirby and let them introduce themselves. Gentlemen, go ahead.
Thank you. And as Frank is shifting over to share the screen, I'm Chris Kirby. I'm an attorney here in Bastrop with Tuck Law Group. Over the I'm now in my 32nd year of practice. Over that time frame, the majority of what I've done is estate planning and elder law. And although I don't isolate my practice to it, the majority of it now is in elder law, estate planning, guardianship, probate, real estate, sort of everything that surrounds the small business owner and the family here in our county. It's a much changing county right now. This is a conversation that I will focus on estate planning for your business, but the reality is for the small business owner, there's really so little separation between life and business that it really is about estate planning for yourself. And so we'll see that a huge amount of overlap in those two things. I also want to just I'll periodically keep an eye on the clock because I certainly want to stay out of Frank's way because he's got a lot of things to talk about in the world of pre-planning for end-of-life stuff, which obviously is the end product of all the estate planning, right? So I'll certainly do that. Frank, do you want to take a second to introduce yourself before I get started chatting about the estate planning stuff?
All right. Well, I'm Frank Weiser with Mars Jones Funeral Home and Mars Jones Newby. We merged with All Faiths, and we are in the old All Faiths location, right across the street from the VFW, for perhaps one of you who may not know that. So we're excited to get into the new building, and so we're always available. So however we can help you. A lot of people may not consider that this is something that has to do with estate planning, but as Chris said, personal life and business life are also kind of intertwined, and the passing of a small business owner not only is stressful for the family just for personal reasons, but you've also got a business to contend with that you may not be expecting. So trying to get a lot of this stuff out of the way as early as possible is always beneficial. So Chris, I'm going to turn it back over to you. Can everybody see the screen? Is it peace of mind?
It's looking good to me. Yeah. And Frank's in charge of the slides, which also means that he keeps me on pace, I guess. But anyway, I do like to say there is a plan for how your last days will be and when you're gone, how your estate will be distributed. The question you must answer is whether that plan will be yours or the government's. And certainly as it relates to your business, that's the case. If you don't have plans in place, then that bad things are going to happen. Doing nothing, you have no control over your stuff now or after you die. You have no control over your own health decisions, and you're really going to burden your family. To the extent that you're a business owner, in terms of the burden of the family, the great challenge that you're going to face is that you're going to be putting them in a position, if you haven't done the appropriate estate planning on the front end. And I am not actually in this presentation going to talk about things like cross purchase buy sells or entity purchase buy sell or the various other ways that you might be able to deal with, transferring your business to the existing business, to your partners if you have any, or doing something with that business. What we're going to talk about here is doing something with yourself so that you're in position to be able to make those other decisions. Family relationships, especially as it relates to if you have a family-owned business where it's you and perhaps one of your children or something, but you have others who are not related or not involved in the business, the relationships are shattered over those things. And over the years, I've seen over and over again the great challenge of a family that has the bulk of their assets tied into their business, and yet they have involved and uninvolved people in the family, and how to be able to balance those things. And I'll just put in a plug that you'll hear throughout this whole presentation at various points in time for the efficacy of life insurance. Life insurance is the cheapest money you'll ever buy. It certainly covers you when you don't have everything else taken care of, and there are a lot of places and ways that it can be used and be used appropriately. And so I'm a huge advocate for the ideas of having an appropriate insurance estate. It's not a great place to invest, but it's definitely a great place to create a safety net. And then also, of course, if you do nothing and you're in a position of being in either having to spend some money to deal with the transfer of the business, or you're in a situation in which you're subject to death tax. The vast majority of us are not, at least not currently. But given the changes in Washington, the real prospect is that a whole lot more people are going to be subject to death tax very quickly than are now. And so if you don't plan for that, then you lose the advantages that you can take that you have over planning, and you end up draining your estate. What's our next slide there, Frank? So managing your life when you can't. This is really about your statutory durable power of attorney. Now, notice something. Most people think about estate planning as a will. They think that they got to get a will and that takes care of it. But the truth of the matter is that the vast majority of planning, especially for those who've only been married once and have children only within the union of that marriage, in many respects, most of the time, you're going to see your stuff transfer without a will in the same way as it would. Typically, if it's one marriage and kids from that one marriage, you're talking about it going to your surviving spouse and then to the kids in equal shares. But what happens before then is huge, especially now when we've seen this huge uptick in the various aspects of dementia. There's Alzheimer's, certainly. There are also things like vascular dementia that come up and really impact the person in the same way. But there comes a point for the vast majority of us when we are not able to take care of our affairs ourselves. And to do that, you really need a power of attorney. And if you can do that while you're competent, it's golden. If you don't do it while you're competent, it becomes much more expensive and much more difficult for you to manage. A couple of special considerations there and for us to think about in terms of planning. Blended families, you've been married more than once, or in Texas, you're not married, but you hold yourself out as husband and wife, which means you are, for all intents and purposes, married as common law married, that kind of thing, having offspring from outside the marriage. The distribution, intestate distribution, which means distribution without a will, is really pretty tough in Texas if you're a blended family or you have kids from outside the marriage. For example, I had a client who died without a will. He'd been married for 37 years, and keep that number in mind, and he was in the Air Force, had 4 children with one wife, one marriage. But during the time that we were going through probate, we found a big pile of letters, all of which were addressed, "Dear Dad," from a 30-year-old woman in England. Guess what? Well, on deployment, he had some sort of dalliance. And at that point, because there was no will, that woman in England owned half of his portion of the real property and 2/3 of his portion of the personal property, not his 4 kids, not his wife. The consequences of not having a will and having things pass intestate for blended families are huge. Also, while you're thinking about all of this, end-of-life conversations. What are you going to do if you can't feed yourself, if you can't speak, if you can't walk, if you can't drink? What are you going to do about pain meds? What are you going to do about managing? And think about this in the context of your business, right? What happens if you have an order cycle in your business to be able to order the raw material that you need to be able to build the things you build? What happens with all of the jobs that you are doing right now if not only if you pass, but also either temporarily or permanently, you're incapable of doing the things that you do now, right? What happens if you have a car wreck and now you're suddenly incapacitated, mentally incapacitated? You can't order, you can't build, you can't do whatever it is that you do. Who's going to step in and do those things? How are those issues going to be managed? Who's going to be in position and power to be able to make decisions on your behalf when you can't? And if you have not done the things like a power of attorney that are necessary to do beforehand, then it's going to be a long drawn out. It's going to take a couple of months for us to get that done under an immediate, permanent or temporary guardianship. it becomes really complicated and it becomes immensely more expensive. You're talking hundreds of dollars for a power of attorney versus thousands of dollars for a guardianship. Then, if you've got special needs folks, that kind of thing, those are always huge issues. And then, of course, Medicaid planning, because everybody wants the government to pay for their nursing home. Right now in Bastrop County, nursing homes are roughly $5,000 a month or more. And that can drain an estate very, very quickly. Again, from a business planning perspective, let's think about that, because with business and personal finances being so intertwined, even if they're appropriately segregated for tax purposes and corporate preservation purposes, still, if you got to draw $5,000 a month off to pay for the nursing home for your wife or for your husband or for one of your kids or whatever the case may be, you do not have those resources available to the business. And if you're like me, at the end of the day, if I have to pull more out of my business to take care of my family, that's exactly what I'm going to do. And so how do you plan for that? How do you deal with that so that you don't have that cause the downfall of your business because you're doing what you need to do to take care of your family? Then, of course, if you have unique possessions and things like that, go ahead, Frankie, if you'd like to flip that slide, thanks. The unique possession piece, right now I have a client, for example, who owned an antique store and has a home full of unique possessions, and she's now in a nursing home. What are we going to do with those? Advanced burial planning, Frank obviously is going to talk about. I think life insurance is huge. Long-term care, insurance, by the way. Micah and Brad can probably talk a lot more about that than I, but there's been a huge evolution in those products. There's some really interesting ones that can do things like pay a death benefit if you don't use them during life. It's definitely worth looking at a certain point in your life if you have the resources to pay for it. I will tell you, in my own world, I bought a long-term care policy for my mother who had chronic obstructive pulmonary disorder when she was 72. And as a result of us owning that policy, she died at home with 24-hour care that we could afford. It was incredible and really helpful. Personal property considerations are ones that you always have to deal with, and business property is certainly one of those as well. And then also I like to talk about, always have this sort of idea of an I love you drawer. Where is it if I had to airdrop into your life and find everything I needed? Insurance policies, business contracts that you have with vendors, who's taking care of stuff, what are your employment contracts that you have with people working for you, things like that. Where would I find them? And add to that list, where would I find the passwords to get into your computer to find all the junk that I need to find, right? I mean, there's just a lot that we need to think about that we don't, because we're just doing life. And there comes a time when it's a good idea to take a quick pause, take a deep breath, and think about what it is that would need to happen if suddenly you were not there. So, just in terms of what these sorts of things cost, if you're going to do a full-blown estate plan for yourself as a married couple or for a single person, these are the general costs that you'd find if you came to me. I think they're basically about the same for those who do real estate planning. I will say, and this is not a dig on any of my colleagues throughout the county. There are a lot of fantastic lawyers in Bastrop County, but I would suggest to you, especially if you own a business, that you need to talk to somebody who does this as a real part of their practice, not as an adjunct to their personal injury practice or whatever the case may be, especially during this season when there's so much change going on in federal taxation and that kind of thing.
Chris, did you want to get your Latin in there down at the bottom? I know you.
I don't even remember what it says, to be honest with you. No, I was being way too smart one time when I wrote that down. Yeah, so anyway. Let's go ahead. So, that's the short version of my stuff. I do need to tell you, there are a couple other, as we look at all of this, you need to think about the fact that you get a power of attorney to take care of your things. Absolutely critical for the business owner. I did not mention the medical power of attorney when I was talking about that, because that's for you. And presumably, if you have your affairs in order on the business side, then your family gets to take care of you on the medical power of attorney side. But what you do with that, obviously, a medical power of attorney is going to take care of who's going to make the medical decisions for you. Actually, two other things I'll say. One is, in Texas, unless you own property outside the state of Texas, or you're in a blended family, Generally, inter vivos living trusts are not really necessary. If you have the complexities of having properties outside the state, or you have the complexity of having a blended family, sometimes it's a good idea to have a trust. But trusts are relatively expensive relative to the cost of a last will and testament, and they're just really not a huge necessity like they would be in what are called the probate hellholes of places like New York or Florida or California, where a lot, frankly, of our clients these days are coming from, particularly the left coast. So a trust is not as necessary here as it is elsewhere. There are a lot of trust mills that'll come around and they'll say, oh, you got to get a trust. Keep this in mind. A trust is like an empty bucket. It says that I'm going to create the Chris Kirby Living Trust. Well, that's all well and good, but all it is a document, and there's nothing in it unless I transfer assets into that trust. I have to transfer my business assets, my house, my other properties. Those have to be now owned by the trust, or you end up in probate anyway, okay? And so if you have clients who have a trust, you really need to take a hard look at Schedule A and see what exactly is in that trust. Right now, I'm dealing with a property in Smithville that a woman in California owned when she passed, but the problem was she never put the Smithville property into the trust. And as a result, because she passed away without a will, only with a trust, we're having to find 14 heirs. We're having to go through a conservatorship transfer from California to Texas so that we can get everybody to sign off on a 0.2 of an acre piece of property in Smithville, Texas. The trust did nothing for her in that context. And so if you're going to do a trust, you have to do it, and then you have to fund it, and then you have to watch it. They are fantastic when they are needed. Oftentimes they're not. What oftentimes you will want to do is have a will that deals with and embraces the business assets specifically, so that it will say what happens to, or who's going to be able to manage those things. So you can have a contingent trust, testamentary trust, that says if in fact there are any business assets, then we can deal with it at that time. And in essence, those assets fall into the trust to be managed after you pass, but it doesn't have to exist while you're alive. It just eases the management and the hassles of having to deal with a trust while you're going. So there are a lot of things to think about with this. The primary thing that I would say to anyone who's thinking about estate planning for their business, great, fantastic, you're thinking about it on the business side. I would say to you that at least as important, actually much more importantly, just think about estate planning for yourself, because at the end of the day, the business is only an alter ego or an extended sort of piece of you. And so you need to handle things, think about things, and manage things from that perspective and for yourself as much as possible. Since I managed to sneak my way through this, going pretty quickly, I do want to say one other thing, just as a general matter for you in terms of business planning and estate planning. The second biggest problem with businesses, obviously, other than them just sort of having the founder die and no one's there to manage it, no one's there to figure it out. There's actually was formerly a very successful business in Smithville where the founder unexpectedly died, and it fell to the founder's spouse, who was not prepared to manage it. And there's been tremendous upheaval with that. That's business planning, not estate planning. But the other piece to think about there is that I often tell clients of mine who've gotten sued that, it's sort of a badge of honor. Think about it. Nobody sues where they think they're going to squeeze blood from a turnip. They sue you in part because they think there's something there to take. And one of the things that I'd say there is the biggest single expense in any lawsuit is going to be me. It's going to be the lawyer protecting you from whoever is coming after you. The best way to mitigate or manage that cost, frankly, for most of us and most of our clients, is an incredibly inexpensive umbrella policy. You can go out and get an umbrella insurance policy that's going to sort of catch anything that's not caught by the other insurances you may have. And those umbrella policies, yes, they'll pay the judgment if there is one most of the time, but more importantly, they'll pay the lawyers. It's probably not going to be me or anybody else in Bastrop County. That's okay. you're going to have your lawyers paid for by the insurance company, and that's going to preserve and protect your business. So yeah, it's not estate planning, it's business planning. But again, thinking holistically about the fact that our lives and our businesses are really the vast majority of how we spend our waking lives. You need to be thinking about that one as well. So happy to take questions, happy to step aside from my friend Frank, and just happy to have you guys here. Hope this has been helpful. Thanks.
Thank you, Chris. That was good. Better than usual.
I thought it was always great. Come on. Anyway, so thanks.
So let's shift gears here. All right, funeral pre-planning, the exciting stuff. This is what you've all been waiting for. So let's ask why this topic is important, especially for a business owner.
Frank, did you want to share screen on this, or?
I thought I did share my screen.
Yeah, it's not coming up for us yet.
Hang on. How is that?
Perfect.
Do you see-
Got it now. Yep.
Got it. Okay. So pre-planning. Why is this an important topic? Well, the AARP says advanced funeral planning gives you the peace of mind that comes with knowing your funeral arrangements are taken care of while lessening the burden on your survivors. I can go on for another 30 minutes, but I think that pretty well says it. That is the meat of what we're going to talk about. The rest is details. Okay. Let's talk a little bit about why we have a funeral to begin with. It creates a tribute for the loved one. I've got to move everything. Yeah. Provides a gathering place for support and fellowship. There's lots of different places we can have funerals. It doesn't just have to be the funeral home, doesn't have to be the chapel, doesn't have to be a church. It could be a barbecue joint that you always went to as a family. We've done them in barns. We've done them all kinds of third party, what we would call a third party location. Oftentimes it is left to the surviving family and they just say, well, we'll have it at the church. We'll have it at the funeral home. Please keep in mind that with some planning ahead, you can put a lot more thought into your own service. And then there's closure at the final resting place. The final resting place is typically, of course, the cemetery, but it could be scattering someone's remains out at the Gulf of Mexico. It could be scattering them in a national park. There's all kinds of different ideas here. And, again, the farther ahead you plan this stuff, the easier it is for the surviving family. And what we're all leading up to here is a transition to a new phase of life for the surviving family. Okay. In the United States, let's talk about some relevant facts here. A death occurs about every 8 seconds. About 350 million plus or minus people in the US, and death is going to occur frequently, just the way the numbers are. 40% of those deaths are sudden and unexpected. Okay. 3 out of 4 deaths occur to people over the age of 65. No big surprise there. Kind of to what Chris talked about, 75% of all strokes, which can be very debilitating, occur in people over the age of 60. And again, if you have a stroke or you become debilitated with Alzheimer's, you more than likely cannot make your own funeral arrangements. So getting this stuff done ahead of time is always a benefit. According to a recent survey, only 1 in 3 people over the age of 50 have prepaid funeral expenses. And that's about what we see at the funeral home. So those numbers all kind of line up. So let me ask you a question, business owner. If something were to happen to you today and you died unexpectedly, what would your family do and how would they feel? Actually, a couple of questions in there we're thinking about. So in the case of an unexpected death, would your family be able to deal with making difficult decisions at a stressful time? And would they be able to afford a meaningful service for you? If the answer to either of those questions is no, or both of those questions is no, you should consider pre-planning. Needless to say, a death can be, even in the best situation, stressful, but if it's unexpected, it makes it even more so. So the benefits, let's talk about the benefits of planning ahead. Eases the emotional and financial burden on your loved ones, allowing them time to concentrate on the grieving process. Again, that's why we have funerals to begin with, is to help the surviving family. Funerals are for the living. I know you've heard that, but now you know a little bit about some of the stuff that goes on in the background as to why it's meaningful. Saves you money by freezing costs and stopping the rate of inflation. If you like to spend more money on stuff than you need to, please raise your hand. We have a special name for you. We have a special prize for you today if you like spending more than you need to, right? You get exactly what you want. Something that most people don't understand is that when mom and dad come in and plan their services ahead of time, they will most likely spend a whole lot less, at least $1,000 less on themselves than their kids would spend on them. So consider that too. You don't have to have the most expensive, the fanciest of everything. You can get what you can afford, right? If your kids want to do more, put that cost on them if they want to do more for you. Protects your family from unanticipated expenses. We go down kind of a long list of options of things that you can get with your service. So we try to make it an exhaustive list. It's pretty much yes or no, or later, okay? Prevents costly mistakes and family squabbles. In an arrangement conference after someone has died and there has been no major decisions made, the thing that families argue about over and above anything else is not religion, it's not politics, it's not football, it's the color of the casket. So if that seems outrageous to you, it's not. It happens frequently. And then again, it creates a meaningful tribute to the life you've lived. So to get started, just simply consider, would you prefer burial or cremation? We're going to go through the thoughtful decision guide here in a minute, fill that out, and then fund your wishes. 3 steps, pretty simple. The thoughtful decision guide is divided up into several sections. The vital statistics. This is what our funeral directors use to complete your death certificate. I guarantee anybody on this call can fill out the vital statistics in about 5 minutes. I don't know how fast your family can fill it out, but it's going to take a lot more time. It always does. So getting this stuff taken care of in advance, simply writing it down and knowing where it is a big deal. Your historical information that can be used either for the death certificate in some cases or an obituary, stuff like that. Family and friends. Families often cannot decide who should be pallbearers at grandma's funeral. Well, grandma can spend 5 minutes and fill it out. Let them know, okay? What your occupation is, things like that. Again, that goes to the death certificate. Some of your personal wishes. I worked with a lady today who said she did not want her glasses on when she is in the casket. She said, my eyes are closed, why would I need my glasses on? So she wants her family to take them off, all right? Same with jewelry. She has some stuff that she wants to wear, so she's written it down in her thoughtful decision guide, and it's very simple. Family doesn't have to worry about it. Let's go through a few FAQs here. These are 2019, 2020, and 2021 questions of the year. Crazy Aunt Mary says, I'm going to hell if I get cremated, and she says she's going to sue everybody involved. How do I prevent that? 3 ways. Fill out your self-authorization for cremation. This gives us your permission to be cremated. It also tells us who to deliver the cremated remains to. Needless to say, Crazy Aunt Mary won't be on that list. Second, I'm going to try to do something here. I don't know if it's going to work, but another form that I think Chris can speak to a little better than I can, is the appointment for disposition of remains. This is actually maybe one of the few powers of attorney that survives your death. You can appoint someone to simply make sure your wishes, your final wishes, are carried out. So if you don't get along with your family, you don't appoint someone in the family to do this, okay? This is a form that any attorney can probably pull down off of the Texas Department of Banking website. Sorry about that. I got to go back all the way to where I was. And third, make sure your cremation is paid for, right? This is something, the next one, Dad has a $10,000 whole life policy, has been told by the nursing home that this policy disqualifies him for Medicaid. Okay. Can he apply that policy to a pre-arrangement and still get on Medicaid? There's a lot of complex things going on here. The bottom line is that that policy probably has a cash value that is disqualifying him from Medicaid. And no, that policy cannot be simply applied to a pre-arrangement. It's too complicated for this forum to explain that, but we cannot do it. There's no document I can create to take that $10,000 policy and apply it to goods and services at our funeral home. Maybe it can be done. We cannot do it. So this comes up all the time. So get ahead of this if you have someone in the family who may want to get on Medicaid and has a big whole life policy with a cash value, okay? What happens if I die out of town, out of state, or out of the country? We have away from home protection that'll get you back. Can I be buried on my own property? I know Chris has come across this one once or twice. The short answer is maybe you can, if your property is big enough. There's a lot of requirements, a lot of maybe roadblocks involved in this. I wouldn't try to talk you out of it if it's something you want to do, but it is something to consider. Do your kids, grandkids, great-grandkids intend to hold that property, for many generations into the future? That's something that a lot of people simply don't think about. I can tell you, especially if you are a veteran, that it is probably going to be less expensive, if expense is your primary driver here, to be buried, say, at a veteran cemetery. I would say that also that somewhere like Oak Hill is going to be less expensive than being buried on your own property, for example. So, why do people put it off? These tend to be more excuses than reasons. It doesn't take a whole lot of time, maybe 30 to 45 minutes for the average person to do a pre-arrangement. If you can't pay for it all at once, we have a lot of different payment plans. And I guess one of the big ones is, I think my kids are going to pay for it. Your kids don't want to pay for it. Your kids don't even really want to talk about it. So take the time, and if this is something that is important to you, take care of it yourself. That pretty much wraps up my side of it. We'll turn it over to April, I guess, to kind of facilitate the Q&A.
Frank, as we do that, I wanted to just mention a couple of things as you were talking. One thing, if you're thinking about, if you own a cash value policy and you're thinking about borrowing against the cash value in that policy, you can do that, and
Yes.
It's actually tax-free. It's tax-free to borrow that money if the policy, there's enough kept in the policy to keep it going until you pass away. If the policy crashes, because the cash value policy is built so that the money that's inside of it supports the cost of insurance. And if you pull all the money out of it, there's nothing to support the cost of insurance. The insurance policy crashes. If it crashes before you die, it becomes a taxable event. So you need to worry about that a little bit. But there are things to think about with cash value policies. One other thing to mention with burial on the property, you can't just go out in the backyard and dig a hole. There are regulations that surround being able to bury someone on the property. And if you do not follow those regulations, and not only are you subject yourself if they figure it out before you pass away, but now you're putting your family in a pickle We had a client recently who had buried his spouse on the property and also had buried an infant child on the property and forgot where he buried the infant child. It's just really a challenge for us to try to do that. Sentimentally, it sounds like it makes a lot of sense. The practicalities of it are very difficult. And then back to it, if you're thinking about all of this as a global matter, back to the business side of things, let's face the reality. There are a lot of things that are going to be pulling on you for money at that point in time. You might want to think about something like a cemetery as opposed to trying to bury on your place. So let me see if I can answer a couple of these questions that had come up in the chat. And the first one was, can capital gains be avoided with a trust? And the answer is no. A trust is a pass-through entity, and so what that means is whatever taxes you would owe as an individual, you will owe in a trust, or someone is going to owe in that trust. Capital gains, short-term capital gains are taxed at income tax rates. So if you have a 20% income tax, you're going to pay 20% capital gains. Capital gains are on the chopping block for the Fed right now to try to raise the capital gains rates. And so if you have people who are considering selling property, significant properties, and want to save on the taxes that they might pay, then they might think about doing that now. Let me make sure that I define what capital gains taxes are as opposed to income tax or estate tax. Let's say that you buy a piece of property for $1,000 an acre and it's 10 acres. Well, that's $10,000 and you paid that. You now have what's called basis of $10,000 in that 10 acres of property. Let's say that that's in Bastrop in 2021. So 3 months later, it's now worth $150,000, not $10,000. Okay, that's a joke. But anyway, so now the difference between what it's worth and what you paid, $150,000 minus $10,000, what you paid, $140,000 of that is what's called capital gain. If you sell the property within 2 years or longer after you own it, you'll pay long-term capital gains. And that long-term capital gains rate will be your sale price minus your basis. When we're talking about business assets or personal assets, it's really important to think about whether or not you want to transfer something to someone while you're alive. Because if I give you, let's say that 10 acres that has the business on it, and that 10 acres is now worth, say, $1 million because of your profitable business and everything else, right? My basis is going to be the $1,000 per acre I paid, $10,000 plus whatever I may have paid to put the buildings on it. Let's say that's another $100,000. But I'm going to give you my basis if I give you the property while I'm alive. You don't get stepped up basis. I'm going to give you whatever my basis was if I transfer the property while I'm alive. If, on the other hand, I wait and I transfer that property to you through my will or through a trust if I use one at my death, now what you get is what's called stepped up basis. In other words, you get whatever the value of the property was on the date of my death when I gave it to you through my death, right? And if the value at that moment was $1.5 million and I sold it the next day for $1.5 million, my basis is whatever the value was the date your basis is the value of the date that I gave it to you when I died. You sold it for the same amount as that value, you would pay 0 capital gains tax. Client of mine in Northwest Arkansas inherited 495 acres from his grandmother. Her father had given it to her while he was alive. She gave it to my client while she was alive. His basis in that 495 acres was $10 an acre. He paid an enormous amount of tax that he otherwise would not have had to pay if it was given during life or at death. So that's capital gains tax. It cannot be avoided through pass-through entities like living trusts. It's going to be paid by somebody. Now let's talk about what the difference is between capital gains, estate, and inheritance tax. First of all, estate and inheritance tax are the same thing. There are 3 kinds of taxes predominantly that we think about, although there are bunches of others like sales tax. But what we think about is capital gains tax, the tax on something you sell, short-term or long-term. Income tax, the tax you on income from whatever source derived. So that means if you have income on a rental property, you have income from your business, you have income from wherever, you're paying taxes on that. And then there's an estate or inheritance tax, which is a tax paid at death if your total net worth is high enough that you have to pay it. Almost no one in the United States pays death taxes, percentage-wise. When I started practicing, if you were worth more than $150,000 on the day you died, you were going to pay an inheritance tax. Now, that number is 11 million per person, 22 million a couple. It's going to come down. This is not a political statement when I say this, but when you have the current administration in the White House, I can promise you that number is going to come down. And so we'll see more people who are going to be, subject to a death tax. Pay attention to that and help them by getting them to an estate planning attorney who can help them build some things that will be able to take advantage of and protect that, the credits that they get against paying that death tax. But that's the thing everyone worries about, and almost no one has to worry about at all. If you're individually worth less than $1 million, 11 million bucks, if as a couple with some planning, you're worth less than 22 million bucks, you're not going to pay a death tax.
Mm-hmm.
So next question was, do wills created in Texas transfer to other states? The answer is sort of. You really need to have your will or your trust at least analyzed in the other state to make certain that whatever disposition you're doing in those things is relevant and can be done in those other states. Oftentimes what it'll mean is you'll have to file the probate in Texas and then file an ancillary probate in the other state. The question really is about if the person lives in Texas and they have a Texas will, but they have stuff in other states, then yes, our rules will control. There's a different answer if you're talking about somebody who came from, say, California and has a California will that comes to Texas, or someone in Texas who moves to Iowa. Is it going to apply there? You would have to check that state's laws to see what the impact would be on the transfer when they're in that other state outside of Texas. I hope that answered the question.
So those are the two questions that were in our chat. Please fill in any questions, or feel free to just pop in now and ask your question while we wait to see if we get any other questions. I have a kind of a very specific question for you, Chris.
Okay.
I just want to clarify on the long-term capital gains versus short-term capital gains.
Mm-hmm.
So for example, and I'll just use my own, something that I have in my family as an example. When my grandmother passed away, she gave all of her many grandchildren stock in the family owned, totally fully owned by the family and controlled by the family business, which is now run by my cousins.
Okay.
Every now and then we'll do a stock payout to anyone that owns stock in the family. And so when you're talking about figuring out capital gains, that in that instance, the capital gains would be paid on anything that's above the value at the time that those stocks were given by the grandparent. Is that right?
So let me see if I'm clear. Are you paying dividends and they continue to own those shares of stock, or do you have people who are selling stocks back into the company and just sort of walking away?
So occasionally that does happen, but in this particular instance, a portion of the family business was sold to another entity. Okay. And created a large pot of money. So all the stockholders decided to do a payout based on the existing, what was valued at each stock value.
And so, but let's say you owned 100 shares of stock. After the payout, you still owned 100 shares of stock,
yes,
correct?
Correct.
So that would not be a capital gains tax. You'll have to confirm this with a CPA, and I'm not one, but my sense is that'd be income taxable, not capital gains taxable, because it's a distribution and not sale.
That's what I was thinking too. And the reason I brought that up And I did talk to my CPA who had said the same exact thing. But the reason I brought that up is because I still own the stock. And of course, I have one child who would inherit that stock. He, again, as long as he still owns the stock and he receives dividends later in his life, that would just be income tax.
Just income tax. Here's an example. I had a friend who's an estate planning attorney in Austin. And in Texas, we don't have any escheat laws. It's spelled E-S-C-H-E-A-T. In many states, if we can't find an heir by the time you go a couple of tiers out, then the state just takes it and keeps it. In Texas, we got to find somebody to take everything that you own at the date of your death, which can be very expensive and difficult. Well, this guy had somebody die in Austin, no will, no heirs, couldn't find anybody, and there was a bunch of stock. Finally found a distant cousin who was literally in a nursing home in Seattle and was getting ready to get kicked out because she couldn't pay for the nursing home. This lawyer flew to Seattle to hand her these stock certificates that were in a company that made lanterns, old gas lanterns. Those gas lanterns had become electric light bulbs.
Wow.
Those electric light bulbs had become car light bulbs. Those car light bulbs were the exclusive provider for General Motors for headlights for cars. Those stock certificates that he carried to Seattle were worth multiple millions of dollars, okay? And so she turned around and said, hey, y'all are trying to kick me out. I'm buying this place and firing everybody, right? But the point is that when or if she and her heirs sold those stocks, they're going to sell them at the basis that was paid. Who knows when, way back in the day when we were still talking about stocks in a lantern company. They're going to have a big capital gains tax to pay because, $2 then became $150 now times X, whatever. And but that's when you pay the capital gains tax, is when those stocks were sold.
Sure.
Now, notice something, because she inherited them and they weren't given to her during life, she gets them at this stepped up value, the date of death value of those stocks, not whatever grandpa bought them for back when it was still a lantern company. She's going to make out pretty doggone well.
Wow. Okay. So that's good to know. Do all these things. So you're really advising to do all these things before your death, not after your death.
No, I'm saying that if you have highly appreciated assets, you're much better off waiting and giving those to whoever's going to get them at your death, not prior to your death, because the appreciation, the difference between $100 and $1,000, if you give it while you're alive, whoever gets what you give them will pay a capital gains tax when they sell it. If you wait until you pass, then the value for tax purposes is whatever that thing was worth on the day you die.
All right.
Very, very different. Okay.
Yes. And you can't really avoid that. What if you instead over several years took advantage of the gift tax and just gifted your child something every year for 5 years?
Well, if you're gifting them an appreciated asset, you're gifting them to them at your basis. It does not get stepped up basis. But you could be avoiding an estate tax in that situation. So, for example, I had a client in West Texas who owned 36,500 acres. Great problem to have, right? But what his situation was all around him, it had been explored for petroleum. He had done none. So for federal estate tax purposes and transfer tax purposes, his property's highest and best use value was as farmland, where it takes like 200 acres to have one cow. Okay. Worth almost nothing is farmland, worth a ton is oil land. Made sense so far? So part of what we had to do was shift that farmland to his son while he was alive by gifting pieces of it to him. Because when you analyze the difference in potential capital gains problems versus the difference in highest and best use value, because his son was going to punch it with oil wells all over the place, it made more sense to transfer it and just eat the capital gains. But that's all the analysis that you have to do when you're looking at complex estates. If you got those problems, and God bless you. But for most of us, we're really just trying to think about avoiding capital gains tax more than estate tax.
You have another question here. If you leave your assets to a non-family member in a will, can your family contest that?
They can try. You know, I mean, let's face it, in America, anybody can fight over and sue over anything, anytime. What you do is a couple of things. Number one, you can't, I mean, you're never going to get those things transferred to a non-family member if you do not have a will. It's just not going to happen. If you don't have a will, then your stuff is going to be distributed based on the Texas Estates Code, not based on your wishes. And sadly, I see that all the time. But my mom really wanted me to get this, but she didn't put it in a will. I can't get it to you. Okay. So that's first thing. Second thing, any will really should have a clause in it. And finally, I get some Latin in here, Frank, called an Interrom Clause. It's spelled I-N, second word, terror, E-M. And basically it says, you get what you get out of this will. And if you argue or try to contest the will in any way, then we're going to act as if you died before I did and you get nothing. And by doing that, it avoids a lot of problems. Now, one other thing to say, businesses are not considered, a business is a hybrid real and personal property for the owners. And so there's some difficulties there, because it's really about the underlying asset. But in Texas, you can put a little thing called a memorandum for personal property in the will, which basically allows you to just write everything down on a yellow pad or a white pad, as the case may be, and say, my favorite frying pan to Judy and my favorite shotgun to Jane. And oh, by the way, anytime you're doing estate planning, the guns always go to the lawyer. But anyway, that's, you know, it's, you know, you say whoever gets what, and then that's not legally required, but obviously your executor is going to do what you've commanded your executor to do, and they would distribute the personal property accordingly, whether it's to a family member or not. So like when my mother passed away, she had some wonderful friends who she really wanted to have things, and she made a list of those things and we made sure that they got them. Other thoughts or questions?
Those of you that are on, if you want to jump in, please feel free to ask your questions. We have about 5 more minutes.
While you're thinking about that, I want to say one thing about on the pre-planning side. Frank talked about the color of the casket. The truth of the matter is that I tell people, do not, you know, torture your children, your loved ones, your spouse, with forcing them into being the ones who say, you know, this is what mom or dad wanted. You know, the more you say those things, it's not just about making it easier. It's not just about making it less expensive. Hear me when I say this. If you want your family to stay together, then you make sure that if they're mad at anybody, they're mad at you. You're gone, you don't care. But, you know, it's like everybody else is they'll be mad at you for a month, and then oh, dad was so, you know, whatever. But if they get mad at each other, they stay that way for a long, long time. And so if you want your grandchildren to have relationship with each other, if you want your kids to stay in relationship with each other, then you really need to make the difficult decisions, and you need to put them in writing. In the case of prepaid stuff, that's not only the casket, but what you're going to wear and that kind of stuff. Don't get them arguing over whether they're going to buy a $100 dress to put you in or a $1,000 suit. I mean, it doesn't matter, right? It doesn't matter to us. It does matter to them. And so let's just make sure that we are really talking about peace of mind and with all of these things. And it certainly is peace of mind when it comes to how you're going to go about just taking care of that last moment. On a business and from a business perspective, the last thing you want somebody to have to worry about is all of the funeral planning stuff while they are at the same time trying to keep your business you've spent your entire life building going. So if you'll make those decisions for them, if you'll get that stuff done on the front end and taken care of, then in that most emotional time that they're going to have, they'll be able to focus on the things that are going to make long-term or are going to be really important in the long term for themselves, their business, your kids, your spouse, whoever. So I can't emphasize enough how important it is to plan on the front end on all of these things. Anyway, I've talked enough. Thank you so much for taking the time. I hope this has been helpful.
It has. Thank you so much, Chris, and Frank as well.
Thank you all for coming.
Absolutely. I appreciate you both so much. I'll remind everyone that's on the class today that this class will be archived on the Smithville Chamber of Commerce website, smithvilletx.org, as well as on our Facebook page and on the Smithville Library's Facebook page as well. Feel free to go back and refer or send it along to anyone you think it will be helpful to. I again want to thank our funding partners, the Texas State Library and Archives Commission and the Institute of Museum and Library Services. I appreciate you all very much for being here today, and that concludes our class. Thank you.
Thanks again, everybody.
Thanks, April.